and welcome. Now, there have been two major court decisions in Nigeria this past week that are now big talking points across the country. First, the Federal High Court in Abuja nullified the primary that produced the governorship candidate of the People's Democratic Party in Edo State, Asue Ighodalo, sending shockwaves across the political landscape of that state and dramatically altering the equation in the upcoming governorship election in that state. The court, presided by Justice Inyang Ekpo, ruled that the PDP governorship nomination processes were non-compliant with its own constitution as well as the electoral guidelines, and decided to set all the processes leading to the party's governorship primary held on February the 22nd, now 2024, aside. In simple language, the court invalidated the nomination of the candidate, that's Asue Ighodalo. The judge ruled that 378 ad hoc delegates who were supposed to vote at the primary election were unlawfully excluded by the PDP. So as it stands, unless the PDP successfully appeals the ruling, it might not be able to field a candidate for the election. Well, reacting to the ruling now, the Edo State chapter of the PDP insists that Ighodalo is still the flag bearer of the party ahead of the September 21st governorship election. It maintained that no eligible delegate was excluded from participating in the primary election, which accreditation, polling, counting of ballot, collation, and declaration of results were publicly conducted, monitored by officials of the Independent National Electoral Commission and relevant security agencies at the Samuel Egbomudia Stadium in Benin City. Well, that's the position of the PDP. So we all wait to see. Obviously, the party is definitely going to appeal. We wait to see what happens. Now, let's turn to the second court case now. This time, it's on Rivers State. The Court of Appeal there, the Court of Appeal sitting in Abuja this time, nullified the decision of the Rivers State High Court, which stopped the Speaker of the State House of Assembly, Martin Amewule, and 24 others of his colleagues from parading themselves as members of the House. The Rivers State High Court had said the 25 members had lost their seats for defecting from the PDP to the APC. Now, the State High Court made the ruling by way of ex parte order, but the three-member panel of the Appellate Court has now held that the Rivers State High Court lacked the jurisdiction to grant that ex parte order. The Appeal Court held that Section 272, subsection 3 of the Constitution gives the Federal High Court powers to determine whether the seat of a House of Assembly member has become vacant, adding that the Federal High Court has the exclusive jurisdiction to determine if the seats have become vacant and not the State High Court. It therefore voided the action of the Rivers State High Court, effectively returning the 25 members to the State Assembly and Martin Amewule as the Speaker. Of course, Victor Okojumbo, the man who has been parading himself as the Speaker, leading two other members of the House, says he is not going to accept that ruling and would be heading to the Supreme Court. So we'll wait and see what happens. But let's try to unpack all of this with Justice Ojieno now, who is a legal practitioner. Justice, you're justice, but you're not a court. You're not a court judge. I love your name, but help us to understand. Let's start with the last the last case now, that of the Court of Appeal on Rivers. Help us to understand it, because some people, probably for political reasons, have been giving it different interpretation.
Okay, for me, I think that the Court of Appeal decision is very, very simple and straightforward. We must always remember that we usually say that jurisdiction is the lifeblood of every case that finds itself in court. It doesn't matter how well conducted, how brilliant the lawyers are, how brilliant the judges are. It is until the court itself has jurisdiction, that is when it can rightfully be said to have decided on a matter. So I feel that it's a simple decision for the Court of Appeal. No matter how political or how emotional anybody feels about the matter, the Constitution has expressly given jurisdiction to the Federal High Court, and straightforward, I fully 100% align with the decision of the Court of Appeal on this situation. And Yes, having said that, I must also say that as much as possible, the NJC too should look into this matter because it's becoming a pandemic where courts will know clearly that they do not have jurisdiction. Yet, for political reasons, they will still sit over it. But we saw it happen in Kano too, where a federal high court was practically trying to decide whether a legislature has power to make certain laws or not. And a federal high court was practically sitting in judgment over chieftaincy matters. So I feel that at some point the NJC has to come in and correct some of these things that politicians are forcing members of the judiciary to delve into.
But Justice, let me ask you this. Does it mean the judge, that judge of the Rivers State High Court, that's Justice Wale, who actually issued that ex parte order and actually had this case in the first place, for a judge of his standing, does it mean he didn't know at the time that he didn't have jurisdiction? Why didn't he decline it?
Okay, sometimes the way ex parte matters work, because of the nature of such matters, there are really no bountiful arguments before the judge. So it's possible that the judge may just, maybe based on the affidavits of fact deposed by whichever lawyer is before it arguing and telling the court how important and how dangerous it will be for the ex parte order not to be granted. Ordinarily, sometimes, yes, we see some of these kind of mistakes or decisions pass through the cracks.
Do you think this was a mistake, or do you think it was a mistake, or probably a deliberate mistake? Because the reason I'm asking this is, look, let's not deny it. The judiciary has become somewhat complicit in this whole political game that is played, not just in Rivers State, but everywhere. We've seen judges come out to issue controversial ex parte order when they clearly know that, what they're doing is wrong. But, they just damn every consequence and go on to do it. It's not something we can deny.
And that's why I'm saying that the NJC should further and more strongly look into this issue. Maybe sometimes when some of these judges make some of these mistakes, we should count it that, okay, they were not even competent to hold that office in the first place. And they should be, because again, we must remember that deterrence is what actually prevents the majority of people from doing wrong. It is not necessarily because we are looking. It's impossible to punish everybody that does wrong in a particular legal regime or in a particular territory. So that is why people must be made examples of. And I feel that maybe this is one of such decisions where we'll see that, okay, it is practically politically motivated. A state high court should know that it can't give a decision in a matter that involves election, especially not just local government elections.
Now, Victor Kojumbo says he is going to appeal. He and his group, they're going to appeal. So as it stands now, following from this ruling, is it clear that as it stands, on the basis of this Court of Appeal ruling, that Martin Amewule is the Speaker of the Rivers State House of Assembly?
Okay, because there is still room for him to go upstairs and get his and get clearer answers or more firmer answers. Maybe we can say that, okay, he still has the right to go upstairs. There's an automatic right of appeal for everything, almost everything under the sun, except the matters that the Electoral Act or the Constitution have said shouldn't be dumped at the Supreme Court. And that's why, as much as possible, we have been calling for the Supreme Court not to be the dump yard of every matter that starts from every nook and cranny or every matter that is so undeserving of the time and legal sagacity of the justices of the Supreme Court. And this is one of the matters that I think should stop at the Court of Appeal. It shouldn't be it's something that the Supreme Court again will have to attend to and waste its time on, because it's a matter that touches on a state or a subnational of the federation, and a state as crucial to the Nigerian economy and existence as Rivers State. So I want to suggest that there's no time that we won't make the Court of Appeal the final court for most matters on the face of. In fact, they should make the Court of Appeal the final court on all matters, and let the Supreme Court, just like the American Supreme Court, have the right to choose which matter they want to decide. It shouldn't be as of right as is in this case, because it is so clear. It is even almost brighter than the sun that the court that gave that decision never ever had jurisdiction or any other jurisdiction in the first place to have given that decision.
Well, it's unfortunate, but you know the rule is that people can actually, I mean, however stupid, quote and unquote, a case is, it can still go up to the Supreme Court.
It's unfortunate. We have to just obey it because of the rule of law.
But you know what? It's lawyers like yourself. I mean, I'm not saying you especially, but it's the same lawyers who would advise, you know, their clients to test, to continue to go up until there's nowhere to go to. So you
yes, yeah, Mr. Badmus, we must also note that the Supreme Court has not also been docile in this matter. They also practically discipline lawyers that bring flimsy matters before them. Not just the Supreme Court, we've even seen high courts go beyond the lawyer-client relationship and impose penalties directly on the lawyers and not allowing them use the cloak of, okay, I'm merely carrying out the instruction of my clients. You should be smart enough to know that if your client is forcing you to do something that is unethical or that is an insult to the temple of justice, you should be wise enough not to indulge that client and now come to desecrate the temple of justice with such matters. So we know that the judges at the High Court, the Court of Appeal, and the Supreme Court have had many occasions, not just ordinary lawyers, but including senior advocates. They deal with them, they impose direct heavy penalties on them, and they specifically say that, no, this is not a penalty on the party, but a penalty on the lawyer.
And honestly, if you ask me, that's what I keep wondering. You're going on appeal, so you're going to tell the Supreme Court that, look, the appeal court got it wrong. The lower court had jurisdiction. The state high court had jurisdiction to have heard the case. Well, we'll just wait and see. But let's quickly turn our attention now to Edo State. The court has made a pronouncement, a federal high court in Abuja, invalidating the processes, basically invalidating the Edo State PDP governorship primary. But then you have the PDP chairman in that state coming out to say that, you know, that nothing has happened and that the candidate still remains the candidate of the party. So if the party does not appeal against this ruling, what happens? Okay,
the challenge that I may have commenting exactly and explicitly on it is because everybody is still saying that the certified true copy of the judgment is not out. So we have not even seen clearly the release that are granted by the court. But since the PDP people are, of course, which I expect them to do, they have to try to even strain all arguments to try to interpret whatever is on ground in favor of their client. What happens, therefore, if indeed the CTC comes out and the process that brought out Asoye Godalo is nullified, it therefore means that they have to try to expedite the process of appeal in order to be able to get a judgment in their favor before they will be able to proceed with the elections. Otherwise, it's just a giveaway for the other gladiators. I don't want to say. So
the way it is, the PDP would be gambling if it chooses not to appeal and you know, subject the court.
No, it would be wrong for them not to even appeal. For whatever it is worth, they have to try to clear the air. If even it is for PR purposes, if even there are no reliefs specifically restraining Asoye Godalo from contesting the election, they must still appeal for the sake of PR, because I don't.
No, but in this case, it's even beyond PR. I mean, this cannot just be for the sake of PR. This is something very serious.
Yes, I fully agree with you. And that's why I'm saying that for whatever it is worth, if even it is PR, then, and that's why I'm also saying that I'm really constrained by the fact that I've not seen the certified true copy of the judgment. Because if the judge in fact said that the process that brought him out is null and void, he can say that the process that brought him out is untidy. That's an interpretation that the PDP is taking. So if they merely say that it's untidy, then it means that it doesn't affect the substance of the matter. It just affects the coloration, the PR
now,
of the matter.
Let me ask you this. If a judge invalidates the entire process leading to the nomination of a candidate, what does that mean?
That's a difficult one. Well, and that's why I'm saying that they are straying the argument to say that there are some things that the court has not expressly awarded. Because again, we usually say, I think the case is Ekpeyong and Ekong, that the court is not a Father Christmas. It is what you ask for that you will get. At some point too, you are talking about, essentially what you are talking about is what's the consequence of this kind of decision, even though the court didn't expressly say that he is no longer the primary candidate or something like that. Yes, to a large extent, that is what it means. But again, the court didn't expressly say that he is no longer the candidate, and because of that, they are harping on that in order to still be able to stage their candidate, which is the PDP, and I really don't blame them. And this, to a large extent now, and that's why I keep saying that I've not seen the CTC. For example, this to a large extent will now show the importance of court judgments being very clear. So it's possible that we will see the CTC now, and it will be very clear that, okay, it didn't rule in a particular way that we were thinking that it ruled, or it ruled in a particular way that we were thinking that it ruled. So that is why, for me, as much as possible, I'm waiting for the CTC in order to be able to say that, okay, this is 100% certain the implication of these words that I have before me. Because if that is not the situation, reportage might just be a little mistaken, and nobody, no lawyer should confidently and 100% decide a matter or interpret a judgment which it doesn't have a CTC of it in front of.
All right. I'm not a lawyer, but I know if the PDP chooses not to appeal this, then they'll be working on dangerous waters. Justice Ojeno, thank you very much for coming on the program. Thanks as always for your incisive contribution. Thanks a lot. Yeah. All right, we'll take a short break, but we'll be right back, and this time we'll be discussing something else, and that is what is going on in Nigeria's oil industry. Stay with us, don't go away.
Opinions are free, facts are sacred, but truth is universal.
How, in practical terms, can we, for instance, de-escalate the tension?
When you go into public office, you must be ready to answer to the people.
We know where the enemy is. 3 places. The Lake Chad Basin, the border area between Nigeria and Cameroon, and then the Sambisa Forest.
On DEJI360, we give you a complete dose of everything. Opinion, facts, and undiluted truth.
I hardly believe what politicians say in this part of the world.
A new Nigeria is possible, a future is possible.
We delve into the issues, dissect it so that you can understand it, and use it to take action.
I don't think there's any need for any governor to look for grant for ranching.
DEJI360, dissecting the issues.